Hello, girl.
Hey there, how are you doing?
I feel like I've missed you, and hopefully a few other people have missed us too. But we're getting the band back together.
That's right, we are. Welcome to Real Smart. For those of you who have missed our last couple of months of episodes, that's because we didn't have the last several months of episodes. So we're
Yeah,
back, and I think they're probably going to be pretty glad, Cheryl.
I think so too. I got a couple of questions of, are you guys going to do some more? And I think that the struggle has been your schedule and my schedule, which is good. But I did like that we were doing these, and I think we have a plan to do it a lot more consistently going forward.
We do indeed. But let's jump right in because
Yeah.
we're kind of taking a new tactic this time around. So, for anybody who listened to us before, we're approaching things a little differently. We're going to have, wait for it, weekly episodes.
Woohoo. We're committing to it. I've
We
I've
are.
committed to a lot of things this year. I was willing to commit to this as well.
Absolutely. Well, I'm always willing to commit to things that I enjoy. So talking to you about real estate, talking to our friends out there in podcast land about real estate, that's something I enjoy and definitely worth making time for. So along with our weekly episode commitment, we're also starting things off with a little bit of a theme this time
Yes.
around. So we're talking about breakups. And I'm a little conflicted, not being a huge fan of Valentine's Day and made up holidays, but is February the right time for us to talk about breakups when we're supposed to be all, googly heart eyes and gaga for love and all that? Is this the right time, Cheryl?
I mean, I think that this is a month that cuts both ways, right? And I think that's a lot of what we're going to talk about here.
It is. And there have been some pretty notable breakups already in 2026. There's a few out there. If we want to dabble in pop culture for a minute, Bill Hader and Ali Wong, maybe my favorite comedian couple, announced that they were breaking up.
That's just not funny.
It isn't funny. It's actually, they were like a comedy dream come true. And now
Right.
if those crazy kids can't make it, and then the big one dominating pop culture headlines, of course, is the Beckhams, an entire family breaking up. That is a page 6 dream come true.
I am happy not to be on page 6. How's it sound?
I'm happy not to have page 6 be interested in me at all.
There
I,
you go.
when you stay off of reality shows, you get to also stay off of page 6.
There you go.
But that's not the kind of a breakup we're talking about. What are we talking about this month, Cheryl?
I mean, I will say, because part of this comes from the fact that I've had themes for the speaking and the teaching that I'm doing. And I also bounce it off of fictitious, made up, bogus holidays. And Valentine's Day just seemed to fit right in with that. But obviously, we're not going to talk about the personal side of things other than the fact that obviously real estate transactions can be personal. But I do think that it is a great idea to talk about trying to hold deals together, how to handle them when they break up. And then also, because I don't think we talk about it enough, and when I touch on it or deal with it very specifically in classes, the brokerage side of things, both like between a client and their professional, or between the brokerage and the real estate agent. And I think that those things are very much worth diving into.
Absolutely. So, if anybody saw the name of this month's series or your February class,
Yeah,
which is Breaking Up is Hard to Do, they might have thought that we're talking about divorce in real estate. That is a topic for another series and one that I'm sure we will get to because that's a topic that you and I love to delve into. The things like divorces, estates, deaths, things that affect the deals. However, for the first episode in this series, we are talking about contracts breaking up, the sales contract, an agreement between a buyer and a seller, and when those things break up, how to terminate properly and under what circumstances you can.
absolutely. And, as someone who has to deal, usually you think of closing attorneys only dealing with the things that successfully get to closing. One of the things I do as part of the law firm is that I write the 10-day letters. So I probably more so than a lot of closing attorneys see a lot of the nitty-gritty of the termination side of it. And as someone who holds a real estate license and has never sold any real estate, I definitely have some opinions on better and worse ways to handle the actual terminations of the contract.
Absolutely. So this first episode, we're covering when the deal ends, how to do it properly, how to do it correctly, cleanly. And I think it's always important because most of our listeners are probably realtors. In other words, members of their local, state, and national realtor association. How to do it with a degree of professionalism and, of course, within the bounds of the code of ethics. So when we're talking about contracts breaking down, where do you usually jump in on this topic, Cheryl? Because I know I have my own experiences as a licensed real estate agent who does work with buyers and sellers. But where do you first hear about that kind of problem in a contract?
It is, in terms of the actual terminations, it's when one side has terminated and the other side is arguing about it. And so, from my purposes, one of the things, and we hit this in some of our other classes as well, is I think the first thing that agents should realize or pay attention to is that if their client wants to terminate the contract, you should be able to read aloud the provision of the contract that gives your client the right to do that. And I think that sometimes agents move a little too quickly. I think this is obviously a very stressful part of this because you guys, just like us, we all only get paid if these things close, right? And so, I understand the stress related to it. And there are some times when people will terminate and they absolutely know that termination is going to be a default and that they risk the legal repercussions in their contracts. And for everyone, the majority of what we're going to be talking about is obviously our Georgia realtor forms, our GAR forms. So I will say, because I'm a lawyer and I can't help it, if you want to know what you can and cannot do, I see a lot of things on Reddit. I see a lot of things on Facebook about I want to do this or can I do that? And then people give all kinds of answers. You don't even know what state these people are sitting in when you're answering the question. But a lot of, we have forms. We have, in my opinion, good forms,
Mhm.
well thought out forms. And I think we don't always read our forms in terms of what we can and cannot do.
Well, we're just coming out of obviously the first month of the year
Hmm.
when our new forms in Georgia drop. Now, a lot of times there are entire forms that don't have changes to them, but of course, the ones that do change are usually pretty substantive changes that
Yeah.
we hope that all of our realtor members and the non-realtor members who do buy the forms are going to the contracts classes. I also think that that's probably the piece of education that um, I put the most value on. There's a lot of education that we need as realtors and real estate agents, but knowing your forms inside and out, of course, is the one that is the most important to serve the client. There's a lot of other stuff we need to know. But if you are listening and you're in another state, of course, a lot of what we're going to be talking about here today is based on our Georgia specific forms. However, if you, we may be covering a lot of the same things that agents in other states deal with. It's just we can't necessarily comment on what's being said in their forms specifically and whether the timelines and the contingencies are all the same.
Well, and I will also say that even if someone's located in another state, I get forms from other states. So I have had people send me examples of things from Florida and from the Carolinas and from, as many other states as I am talking to people. And you can get good ideas from the things that, the wisdom of the crowd of the things that people are doing. So some of the things that we have in here, as I said, I'm kind of a fan of them, and I think that they may be great ideas. Um, One of the things that I think, and this is something I'm going to drill down on, everywhere that I'm speaking this month, one of the things that I think is probably the least understood is the fact that we have like four main areas of this contract where Yes, there is a person who is in default, and in these situations, it's all buyer defaults. And we have sellers who are potentially jumping the gun because, just because the other side defaulted doesn't mean you necessarily have the right to terminate the contract. And there are four areas where there is, by contract, a right of the buyer to cure, and there are some things that have to happen for that. So I think that is probably one of the big misses that I see.
And you're talking about times where the seller may have the right to terminate if the buyer can't cure or refuses to cure within the time period. And I think, you know, a lot of what I hear, and I'm sure you hear the same thing, is when an agent is working with a buyer, they like to tell the buyer all the times and all the places in the contract where the buyer is protected. Due diligence, you can terminate for any reason. You can just wake up one morning and change your mind. Which is way different than the contracts were when I first got into the business, which we can talk about it another day. That whole property sold with right to request repairs, inspection contingency situation. But we talk to buyers a lot about where they are protected and when they can terminate. And then the very next thing I hear people say is, and sellers don't have the right. All of the power lies with the buyer. So, what do you think about this, Cheryl? Let's talk about when a buyer can terminate and how they are protected. And then
Mhm.
let's move into those seller rights, because I think those are the ones that are unexpected, maybe. Uh,
Absolutely.
so buyers terminating during due diligence, that one's pretty cut and dried, wouldn't you say?
Yeah, I think the frustration point that I have, and that I'll discuss in the classes, and it may end up being a submission to the forms committee at some point, is the fact that, I do like our due diligence period. I think if the length is right for both sides, that works. And what we're creating is basically a buyer option to purchase, which means they're not obligated to do it. They don't have to have a good reason to get out. And the issue that I am finding is that the buyer will absolutely rightfully terminate during their due diligence period, and the sellers will fight that buyer getting their earnest money back. And I don't know, and I haven't talked to anyone else about this, so you're the first person that I'm telling, is that, what happens when there isn't an agreement is that whoever the holder is has to write a reasonable determination letter deciding who gets it. And there's 10 days to respond. And the problem I'm having with these is that the buyer is stuck for 10 days without their money that they have the absolute right to have. And I am wondering, and you can give me money, that they have the absolute right to have. And I am wondering, and you can give me your thoughts of shortening that period of time, the 10-day response time, when the termination is due to a due diligence termination. Like maybe we give them 2 days to respond.
Absolutely. I think that when it is cut and dried, if it is absolutely within the time period of the due diligence period, and there is no question that it was within that appropriate time frame. I've always wondered, when that is the circumstance and there's no question that the buyer gets their earnest money back, why it isn't unilateral. And I know that it is, but the bottom half of our form, calls for, with the release of the earnest money, it has to be mutual. And that's the one piece that I've always found to be infuriating, especially when I'm on the buyer's side, because we know that buyer, they may have already found another house, which, as much as the seller doesn't want to hear that the buyer kept shopping, it is absolutely allowed. They may have kept shopping and found another house. They may have found a house that better suits their needs. They may have had a second choice house, and when a horrific inspection report came back, they decide they need to go for the house that was still in the back of their mind. So I think that would be a worthwhile change, at least limiting that number to something much less than 10. Um, and,
Because
and
it's their money that's being held up, and the problem is that's usually the same amount of money that they're going to use on the next offer that they make. They don't have two buckets of money that they have so that they can sprinkle, earnest money in multiple places.
That's right. And we shouldn't count on a buyer having that much of their assets liquid that they could write another large earnest money check in order to move on while waiting for the seller to. And I've been on that listing side. I've been on the seller side where the seller says, I'm not signing it. And it doesn't matter what you say to them, what you read to them from the contract, what you remind them of, that the buyer had the right to do it. If they simply refuse to sign, they know that they can ultimately just hold up that money and prevent that buyer from being able to move on.
Yeah, they're doing it just for the torture factor. Like you caused me pain, therefore I am going to cause you pain, and that's the only real reason to do it. So,
Yep.
but yeah,
Now, of course, there's two other common contingencies within a typical contract, or one that is getting financing, and that is, of course,
right.
the financing contingency, which I know we're going to spend some in-depth time on that in March when we talk about financing. But in the event that the buyer has been determined to not qualify for financing, the lender can write a letter. There are very specific circumstances. We may not want to go into those today, but they can certainly terminate and get their earnest money back. And then, of course, the appraisal contingency.
Yeah, and we will talk about those more because I think obviously it's very easy to make just like denials it be an entire episode. The only thing that I will say, because it touches directly on this point, is buyers have lost their earnest money for failure to follow the requirements for termination and delivery of a denial letter that have very specific timelines. And you don't have to listen to what one of us says in a class or what one of us says on a podcast. What you really need to make sure that you're doing is when this thing is happening, to pull out that section of the contract, count the days, mark the calendar, follow up with who you need to follow up with. And that failure, particularly to even deliver a denial letter during the 7-day period that they have to do, has cost multiple buyers their earnest money. Just in my own personal, I was the one writing the letter. I think we need to be really, really careful to protect the buyer's earnest money.
Absolutely. And of course, in addition to due diligence, financing, appraisal contingencies, there can be other contingencies that are written into the contract. If a seller agrees to repairs and at the final walkthrough it's found that they haven't been done, that might give a buyer the chance to terminate if they want to, if they want to get to that end stage and
Right.
walk away. So of course, we wouldn't be able to cover the almost infinite number of opportunities. But as far as contractual ones, are there any that we're missing on the buyer side?
I will say that there are probably times when we're not giving the buyer the right to terminate as specifically as we need to. And so that you need to, because those are the ones that we've touched on are the ones that are pre-written into our most commonly used forms and exhibits. But there is, let's say, like the seller didn't have a seller's property disclosure and the buyer is going to ask for one. A lot of people will write a stip that says the seller will give it within 3 days. And there is a GAR stip out there that says they'll give it within X number of days. The buyer has Y number of days to look at it. And if they don't like something that's on it, they have the right to terminate. And so I think we need to remember to also include that right to terminate, because I don't think the buyer just cares about receiving a property disclosure. I think they want for the things to be on there to be acceptable things that they weren't allowed to see. So I think we need to be, you can take that one stip and use it for anything else that the seller is going to give after binding agreement. You steal the language, change the fact pattern on it. And so I think that when we have other ones, it's because agents have done a really good job crafting a right for the buyer to terminate and then just following all the requirements once they do it.
And that's one more reason. And I know if anybody's listened to our past episodes, and I'm sure we will continue to say this ad nauseum, don't write your own stipulations if you're not 100% correct. You're sure you're writing them correctly.
Yeah.
Check with your broker, check with an attorney, go to Smart Stips, which is Cheryl's website, because if you don't have that if-then statement in there, you're essentially taking the buyer's right to possibly terminate and have that power and that protection. You're possibly taking that out of their hands.
Exactly.
Um, so I think before we go too much longer talking about buyer rights, we got to dip into those seller rights, because you mentioned, you teased a little bit that there are 4 places in the contract where the seller actually has the right to terminate, and that is misinterpreted pretty often by agents jumping the gun maybe even having their seller sign that termination without realizing that the contract does give the buyer the right to cure the default. So the buyer defaults, the seller notifies them, the buyer has the right to cure, and if the buyer can't or won't, then the seller can terminate. But let's talk about those four times, and what agents should know about that in order to make sure they're protecting their sellers properly.
Yeah, so we have all of them require notice for that cure period to start. So the buyer has to be notified that they're in default. In two of them, because it is not delivering the earnest money or having the earnest money come back dishonored, that notice is supposed to come from the holder. And then the other two that are on the seller side for notice is verification of funds, and a favorite of ours that we will definitely discuss with financing, evidence of ability to close. So the first one, verification of funds, is only in the no financing contingency exhibit. The evidence of ability to close is in all of our financing exhibits, conventional, FHA, VA, USDA. And so in all of those, there is a notice from someone, either the holder or the seller, that the buyer hasn't done something that they are supposed to do. And then if it's earnest money, the cure period is 3 banking days. So that is going to be a little bit different than our normal days, Monday through Friday, not including federal holidays. For the verification of funds and the evidence of ability to close, those used to both be 3 days. One of our 2026 January changes is that the cure period for the buyer for verification or evidence of ability to close is now only 2 days. We shrunk the total, like the perform period and the cure period, we shrunk it from a total of 10 days to a total of 7 days so that the seller can get that information a little bit quicker. So they first have to make sure that the buyer got a notice, either from themselves or from the holder. They also really, really need to pay attention, because usually if the buyer does not cure and the seller has a right to terminate, they only have that for a limited amount of time. So they really have to make a decision, and it's typically 7 days. You need to read the portion of the contract that you're referring to when this thing happens to you, and not think, oh, I think Cheryl said one time. And so in those circumstances, they need to make sure that they're acting timely and making a decision as to whether they want to cut bait or not.
And I think that I know you've said this several times, and not to beat a dead horse about it, but it really is knowing where in the contract or in the exhibit that verbiage is located, reading it, making sure that your client has read it or that you have pointed it out to them and that everyone understands what it means. And that's not me necessarily talking down, make sure you understand, but really and truly make sure that you understand the number of days. Are they banking days? Are they calendar days? What's the time limit to cure? And then how much time does the seller have after that? Because it's not infinite. You can't let that time period go and then decide a day before closing potentially that you are sick of that buyer and you're going to just terminate them and go back on the market.
Exactly. Or you got another offer during that period of time, and it's been 4 weeks since this issue was raised, and now you're going to keep this thing. You can't keep this thing in your back pocket forever and just play the card whenever you want to. So I think if you get anything from this episode, it is really that there are a whole bunch of this is one of those places where there are some very specific timelines in the contract. As we proved in 2026, we can change the deadlines if we want to. We can change those timelines. So it really is pulling up the agreement that you guys entered into and taking a look and seeing what your options are.
Absolutely. And I know before we wrap up, I know that you are a great creator of forms.
Yes.
And I'm not talking about, I know you sit on the Georgia Forms Committee. However, I know that you also like to create your own forms and checklists or sample language, sample stipulations, etc. Is that something that you might be providing sometime this month to your newsletter subscribers?
I certainly will. So the holder notice of earnest money was created as a GAR form this year, right? And so the only time that sellers might need to use it is if they can't get a closing attorney holder to act, right? So they may, since the closing attorney can't use the forms, the seller might prepare it and send it over. But in terms of the other two, which is evidence of ability to close and the verification of funds, yes, I will be providing the sample language for people to just use on the blank notice form form that everyone has access to, and that way they can just save it and use it when they want to use it. So
That blank notice form, it is so underutilized. And it isn't it just makes your notice look more official. And obviously, we shouldn't be giving notices in just the body of an email. So if you're not aware of that blank notice form, definitely go and grab that from your list of forms and familiarize yourself with it, because that's where you would put the verbiage that Cheryl will be providing. And that means they also need to be sure to be subscribed to your newsletter.
yeah, so we'll post out, I think, some show notes. I'll post a link, and I am on Facebook. I am on LinkedIn. I have a little link tree letter. There is one email once a week. I cannot even do more and would not want to anyway. And it is typically about the things that we are talking about. So it will be very timely. So please subscribe.
And before we wrap up, because that's pretty much all we have for this week for this series, is there anything else you think we need to know about breaking up those contracts?
No, I think just pay attention, read, and have a good conversation with your client, and you will be an extremely valuable resource for them.
Well, make sure you tune in next time to us here on Real Smart. We're going to keep talking about breakups. It will be the second episode in our series, and we're going to be talking about brokerage agreements, buyer brokerage agreements, and those exclusive seller listing agreements, and when those potentially break up, how to do it right. And we hope that we will see you then. So please tune in.
Bye, guys.
Bye.